Everyone, welcome to All You Need to Know About SEC's New Fundraising Rules, hosted by YK Law LLP. In this good weather on the East Coast here, I'd like to bring to you a great panel presenting this very interesting but very very well known topic on the SEC. And a little bit about YK Law LLP. We have 5 offices in New York, California, Texas, New Jersey, and more are building this year. And we are the firm affiliated with the biggest law firm in Asia, YK Law Firm. Today, we have the honor to spend some time with our partner, Chair of Cannabis Practice, Kresimir Peharda. Kresimir is a corporate and M&A attorney. As one of the leading cannabis deal attorney in Los Angeles, he represented cultivators, manufacturers, processors, retailers, MSOs in all stages, and private equity funds and public companies. His clients has raised billions in US dollars through public and private offerings, commercial loans, and VCs. So please give a round to Kresimir for joining us. Hi, Kresimir.
Hi, Chi. Thank you for that introduction. Yeah, so an interesting part of my practice now is capital raising for cannabis companies. I've always done capital raising, but it gets a little more interesting for cannabis companies for sure. So welcome everybody. Hopefully this will be very informative, and we look forward to your questions during the Q&A portion. So let's go to the first slide, please. So a little bit of background on why we're talking about these rule changes. So the SEC has a principles-based approach to its rulemaking, meaning they take really theoretical principles when they craft the rules. And this is a perfect example. This is the basic tenet of the SEC that says that every offer and sale of securities must be registered with the SEC unless there's a valid exemption. And really what that means is, to break it down into 2 things, is what is a security? Well, these days it's almost anything. It includes a token, in initial coin offerings. And so you're looking at cryptocurrencies possibly being securities. You're looking at all the typical interests in corporations and LLCs and partnerships. You're looking at convertible debt, convertible instruments. You're looking at options, warrants. All these things are securities. Secondarily, what's an offer? Well, really, it's any attempt to get investor interest in a specific security. So it's really a discussion, any kind of statement such as, we are offering common stock in exchange for this or at this valuation, that would be an offering. So basically the SEC is saying anytime you talk to someone who may be an investor about your security, about your offering, you're triggering securities laws. And that's important to remember because that's really the underpinning of all of what the SEC does with respect to basically private and public offerings and registrations and exemptions. So next slide, please. So one of the biggest challenges that we've had as practitioners and companies have had is this issue of how do we know who's interested in investing, who's accredited, who's not, how much they're going to invest, and the related problems. In other words, there hasn't been a reliable way across the universe of exemptions and various processes to figure out from the company's side and company counsel side, and also from the finder, from the financing side, really who is going to invest, how much, and really there hasn't been a good way to try to plan for the potential offering. So the communication has been very difficult, awkward, and confusing, with different exemptions allowing different ways of approaching investors or not approaching them, some having outright bans. So here what the SEC has done is really an attempt to kind of revolutionize this process by saying, okay, we're going to set some clear ground rules And the ground rules are now in a new rule, Rule 241, that now will allow companies to gauge investor interest. This is sometimes called testing the waters, but it's really a big improvement from the standpoint of helping clients and companies trying to fund their businesses in a way that makes some sort of sense. So what this rule does is basically set forth guidelines which companies can use to contact investors so as to plan their future financing. Next slide, please. So Rule 241 sets out really what companies can now do without creating any issues with respect to being accused by the SEC of conducting a general solicitation. So now they can reach out to potential investors and indicate that they are raising money. They're not sure under what exemption. They have to indicate that they're not accepting money. They have to make it clear that no decisions are being made, basically. They're not accepting any funds at this point until they figure out at the end of the gauging interest period what exemption they're going to be using and figure out what they need to do to comply. And finally, they have to make it clear that just because an investor indicates they're interested, it's not an obligation. It's not a binding obligation. I would add to that, and the SEC has made clear that companies can certainly ask for contact information, phone numbers, emails, addresses. And I would also add, the SEC didn't address this, but certainly it makes sense if you're going to ask all this information, why not ask these potential investors right away if they're accredited or not? So in summary, what companies can now do is really get a gauge of who is interested in their offering, are they accredited or not, and how much is it likely that they're able to raise, understanding that these indications of interest are not 100%, but they're very informative and can really help the company save time and money in its process of financing. So next slide, please. So shifting to really a 40,000-foot view of exemptions and how money is raised in essentially private companies, we really have the following rules to look at. Rule 504, 506, consisting of 506B and 506C. Then we have crowdfunding and Regulation A. And what is obvious is that crowdfunding, even though it's gotten so much attention in the press over the last close to 10 years, is really, there's not much to write about. 60 million in a year is absolutely nothing if you compare it to the amount raised under Regulation A or collectively under Regulation 506, whether B or C. So obviously these rules have different requirements, different rules, but just to do a quick run through. So in the case of 504, why it's convenient is the fact that there is a limit, but there are no investor requirements. So it's a fairly simple and straightforward way to do it. With respect to Rule 506B, it is relatively attractive. However, there is a cap on the amount of non-accredited investors at 35. And then 506C, in some ways, is the best of all worlds and has been historically the most successful because it allows you to contact everyone in the universe so long as you're limiting yourself to accredited investors only. And then flipping to crowdfunding, we see that while much promoted, the reality is not a lot has been raised under this exemption. And we'll dig into a little bit of that going forward. But I would say the biggest problem is the relative cost of capital under this rule and the low offering limits prior to the rule changes. And then finally, Regulation A, we see is pretty significant. Regulation A really requires a mini registration statement be filed with the SEC. and comments are given, and essentially fairly unlimited exposure to the investor universe is offered by the regulations. So it's been relatively successful. Next slide, please. So one of the significant changes that the SEC made in these new rules is they upped the dollar limit for Tier 2 of Regulation A. Regulation A has two tiers, Tier 1 and Tier 2. And Tier 2 is now really at the stage at 75 million where companies can really look at this and say, really, if we're looking to raise north of 20 million, maybe in the 40 to 75 million range, really we're doing a mini IPO, and the cost of capital in terms of paying broker dealers, paying our attorneys, paying our accountants isn't that high, because we're raising a lot of money here, and we have the ability to reach a lot of a potential investor universe. So it is a nice bump up. I don't know that it's going to massively change things, but it is a significant difference to where these companies doing close to 75 million are really engaging in what are mini IPOs. Of course, the downside with the regulation is that they now have to be essentially mini reporting companies, almost as if they were public companies. Next slide, please. So new rule 504, this is actually in some ways the biggest change. The limit now, the offering limit is 10 million. And that gets to be pretty interesting, because what we're seeing is when we look at angel financing or we look at VC financing, we see that seed rounds and early stage rounds are almost all going to be in the single million digit range. So the bump up to 10 million is really a very nice feature, because again, there are no investor restrictions here with Rule 504. And to the SEC's credit, in the case of Rule 504, they have really upped the offering limit significantly, 10x in the last almost 5 years. So the utility of Rule 504 will be interesting to watch on a go-forward basis, because 10 million is starting to get into interesting figures for capital raising and for many companies doing this. Next slide, please. So the new crowdfunding rule, the offering limit has been bumped up 5 million. Personally, I'm not overly optimistic that's going to change the utility of crowdfunding as a mechanism to raise capital, but it remains to be seen. My take is that it's a very expensive path to go and raise capital, and we'll see later in the case study I will provide why that is the case. But for now, it is significantly an improvement where the previous cap was 1.07 million. We're now at 5 million. So it is a significant amount of money higher than before. Next slide, please. The other part of what the SEC has done with crowdfunding to make it better is they've at least made it easier in terms of allowing accredited investors to invest as much as they want in a crowdfunding campaign. So theoretically, if one had enough accredited investors, they could take up the whole raise without having to worry about any kind of income or asset tests. And with respect to non-accredited investors, the SEC has now said they can use the greater of their income or net worth, which will also help more non-accredited investors invest in companies using crowdfunding as the vehicle for their dollars. How much, of course, remains to be seen. We'll see that over the next couple of years. But these two changes combined with the increase of almost 5x are significant. However, I would say we're still looking at a $5 million cap, and we're still looking at an expensive process due to the mandated use of a broker dealer, or funding platform and the costs of the forms that have to be filed with the SEC. Next slide, please. So demo days are actually one of the most interesting aspects, perhaps not significant to that many companies outside of the technology space, but one of the most interesting examples of how the SEC's principle-based view of what's a security, what's an offering, what's a general solicitation comes to play. So obviously, demo days are a very common occurrence these days, with tech startups participating in them in all the big tech centers in Silicon Valley, Austin, Los Angeles, New York, and so forth, Boulder, and other places. The problem that the SEC traditionally had is the SEC viewed these events as the companies that participate were conducting a general solicitation. Historically, I think that interpretation was a massive stretch, but I understand the concern because now a lot of these demo days are viewable on the internet or live streamed so that potentially anybody in the world could watch them. So the SEC was concerned about this, so they came out with what we now have, a safe harbor. And so they've said to companies participating in demo days, okay, if you do only the following, if you provide the following information, you're not going to be triggering any kinds of registration or exemption worries from us. So it's fairly straightforward. Basically, companies can now give investors and attendees just the basic facts, saying the company's in the process or planning an offering, what they're thinking of in terms of the security, how they're going to use the proceeds, so use of proceeds, and finally, how much room is there left in their raise or their round. And that's quite reasonable. The SEC's also made it clear now who can host these events. It's really now a wide range from angel groups, accelerators, incubators, state and local governments, and universities and educational institutions. So it's going to be really all of the typical groups are now eligible to participate, which is nice so that none of those people really have to worry about these issues. And frankly, most of them were and are unaware of these issues, but by passing this safe harbor, the SEC has just made this a lot easier. Next slide, please. So just a brief case study, and I'll have another one in a second, but to give you a sense of how the new rules might be implemented, I previously had a client under the old rules that was trying to raise $10 million. In this case, it was a cannabis company, and their problem was one that's very typical for companies raising money. They were unsure if their pool of investors had mostly accredited, mostly unaccredited. They were unsure of how many investors they were going to have, and they were uncertain as to the exact states that the investors would reside in. And all of these factors are relevant because they weigh in the decision as to which exemption to pursue, or in the worst case scenario, what registration process to follow. And so in the old world, they really just had to guess. And as their counsel, really, we had to just guesstimate as to what was going to happen and sort of hope for the best. I mean, we were able to actually do a questionnaire outside of these new rules just to get a sense of what was likely to happen. Now, under the new rules, part of the problem that was posed for them went away because, or would go away, because under the new rules, the gauging the interest provisions in the rules would allow the company to directly reach out to as many people essentially as they would want to, and really drill down these facts on how much they were likely to raise, when, and in what states. And this gets relevant because under the old rules, this particular company was looking at raising $10 million in two tranches, $6 million and $4 million. And what that would have done under the old rules, if they were considering Rule 504, is made it very difficult for them to do that. It would have required us to think about alternative exemptions, perhaps splitting the offering in two, doing all kinds of things that just drive up cost, make it harder to raise the money, and make it much slower to raise that money potentially. So now the new rules would essentially wipe that away. Next slide, please. And finally, talking about the rules, one of the most interesting things that has happened is the SEC has now formalized what many people talked about and was really unwritten, an unwritten rule and not formalized, but has now been codified. And that is, the SEC has said if you're going to offer securities to a domestic U.S. audience, you may also at the same time do so to a foreign audience. So to the extent that cannabis companies or other companies that have a very difficult time raising money can find another marketplace, perhaps Canada or some country like that. And of course, they have to comply with securities laws in Canada. Let's not forget that. But if they can find an interesting audience of investors in another country, the SEC's position now makes it clear that so long as they're not targeting US persons and they're getting demographic information on address and telephone number and so forth, and it's clear that they're not on a website or in any other mechanism combining these two offerings, it's not going to be a problem. Those two offerings will not be integrated. They're going to be fine. So that on paper really expands the universe for companies trying to raise money, especially those that think that they can have an interested audience outside of the US and where they're able to find competent securities counsel to advise them on an offering in a way that's cost benefit positive. So it's a very positive move that will also, I think, over time show its benefits to companies trying to raise in multiple countries, assuming they're very careful about following these rules. And next slide. And here, what we have is a proposal, but I think I'm including it in the information being provided because I think it is so interesting and very likely to become law. Finders have always been a difficult gray area in terms of the SEC, but for people in the capital raising community, they've always understood that finders have been an integral part of it. So the SEC has now said, okay, finders can receive commissions so long as you follow our rules, which are you must fit one of two tiers, tier 1 or tier 2. And with tier 1, really the finder doing the bare minimum, the sort of very conservative approach of past good practices, which is just connecting the company with an investor. In tier 2, the finder is allowed to really act as both, as both the person making the introduction and really the investor relations arm of the company, but cannot really act as the broker-dealer, cannot structure the investment, cannot hold money, but can just be the conduit for information and back and forth, can help schedule meetings and the like. So this is a significant change that will certainly make a lot of people who are finders or are thinking about being finders sleep much better at night. And the final thing I want to talk about is an example of a company that is actually going through some of these processes right now. The company is called LeafWire. It's a cannabis social network, and they are using a combination of regulation, crowdfunding, and Regulation D. They didn't specify how they're doing it. But they are now raising funds, and it's interesting because the website on Seed Invest, their funding portal, does not show that the new rules are in effect. That will need to be updated, but basically they're using a combination of crowdfunding and Regulation D to raise the funds. So they're raising convertible debt at $500 minimum investment. And it's interesting to see how an offering like this might have been different had they started it after Monday, which is the 15th, the date on which these new rules come into effect. Perhaps they would have abandoned Regulation CF crowdfunding and instead gone with perhaps Rule 506C only, or some other exemptions. It's not clear because I don't have all the facts and I don't represent LeafWire, but it is interesting to look at that process and their thinking as they went through this, because now many of the options that we just covered are open to them, which were not when they started this offering, I think earlier or late last year. So at this point, I'd like to conclude and shift over to the panel discussion.
Great. Thank you, Kresimir, for the great presentation. I've been learning a lot and taking notes. I think everybody else is also doing that. So now we give the stage to our wonderful panelists. Today we have and welcome our YK partner and co-head of Capital Markets Practice, Claude Baum. Claude has over 35 years of extensive experience in corporate M&A, securities, hedge funds, SEC reporting, compliance, cryptocurrencies, and corporate reorganizations. And we're very honored to have him today. And also we have our own YK consulting team, and we have our investment banker, Tony Zhu, here today. And Tony brings over 30 years of experience working for the big banks. And he's a very experienced financial service leader from consumer to commercial needs. So we welcome all the panelists. Welcome.
Thank you.
Thank you.
Hi, so we've heard from Kresimir, so it seems like SEC is loosening up the rules, and for both, for both investment, for uncredited investors, also investment banks, all the players in the field. So what do you think? I think this is a question for all the panelists. So in adopting the rule, the SEC said it was trying to make it easier to use multiple exemptions, and or set, it has trying to set clear rules for communications between companies and investors, or fix gaps and inconsistencies in offering the money limit rules. And do you think that it succeeded, and why do you think so?
So thank you. Let me try that first. And I'm happy to be here, so I welcome everybody. So look, the securities laws were first enacted in this country in 1933. This was a response to the overexuberance of the stock markets in the 20s in this country, and ultimately which led to the crash, which a lot of people think contributed heavily, although was not the only cause of the Great Depression. So Franklin Delano Roosevelt was elected in 1932. He enacted a lot of New Deal reforms, and one of the important ones was the Securities Act of 1933. That established the principle in this country of really reining in that freewheeling capital investor sort of exchanges, transactions, investments, and really sort of installed the principle of disclosure to the public, not to actually restrict an ability of an investor to invest, but to make sure that the issuer would adhere to certain requirements. And the main requirement was disclosure. Everything that, and the basic principle was everything that an investor would want to know, a reasonable investor would want to know, should be disclosed to that investor. So now we flash forward to, let's say, 60 years later, about when I graduated from law school, or 50 years later. And this was a very sort of vibrant, sort of big market in the United States. And it had developed with those, subject to those restrictions. However, things started changing in the 80s and the 90s, and that was really as a result of multimedia and the internet. And there's just a lot more interest. There's a lot more wealth in this country and other parts of the world, and there's a lot more investor interest. And there's this idea in this country as well that, well, why should only very sophisticated or affluent people have the opportunity to invest in these kinds of companies? Why can't me, a little guy, a merchant, a store owner, a truck driver be able to do that? So there has been really, since about 2000 or so, let's say the mid 90s, an effort to really to keep the lid on still, requiring companies to disclose and adhere to certain constraints to prevent frauds from happening, but at the same time to allow some level of retail investment in our companies in this market. And the idea was also, this is a good thing, helpful to society, good for our financial markets, and also realization that in other parts of the world, these things are happening as well, and America doesn't want to be left behind. So I think the main theme was a tend towards democratization of sort of investments and investment opportunities. And this is just one of those, really the latest iterations of that trend in this country.
Yeah, I would say from my perspective, I mean, it's early to tell for sure, but on paper, I think this is a really positive step forward. I mean, the SEC is finally recognized the importance of finders, for example. I mean, we still don't have the final rule, but they're actually addressing this issue, which was a problem for years and years. And I think unfairly, in some cases, the SEC would go after people who perhaps were relatively innocent in terms of the role they played. And in terms of the communications, arguably that could be one of the biggest ones, because that has been a problem forever. Companies just do not know. I mean, the SEC rules really forced companies and their counsel to try to turn them into fortune tellers. And that's a very difficult process. And then, if companies and counsel got it wrong, then the SEC could come along and punish them. And so it was a bit of an unfair situation in my view. So now at least the gauging the interest, the communication aspect has been improved. I don't know that it's perfect, but it's certainly much better. It's a much more logical process, I think, that they put in place.
Interesting. Okay, so how do you feel, what do you hear from the investors, playground? Like, so do the gouging investors view the new rule helpful, or what do they think?
Well, I think there's a lot more people in this part of the world who were locked out of. Well, let me sort of back up a little bit. There's always been a distinction in this country, in our capital raising community and the capital markets, between the public side and the private side. Public side is, everything that goes on the exchange, IPOs, things that you see at CNBC, let's say. And then there's the private side, which probably over the last 30 years or so has overtaken the public side. So there's a lot of private activity, a lot of capital raising going on. And this is really, these reforms that we've been speaking about have opened up that side of the market to a limited extent to these investors who really, because they weren't sophisticated, weren't affluent enough, were really not allowed to participate. And that, the way that came in, it was the company was restricted from taking their money. So, and that's a good thing. That's helped, again, toward democratization of access to these opportunities.
That's very good. So will this rule make crowdfunding more attractive? And why or why not?
Well, I think it'll make crowdfunding a little more attractive. One of the things I didn't get into is a cost breakdown. So if you look at a deal like LeafWire, I think is a perfect example. If you look at their funding portal disclosure, you see that perhaps on the total amount or some portion of it, LeafWire is having to pay their funding portal 7.5% cash commission. They're also paying equity compensation, presumably warrants on the securities raised.
That's expensive, you're saying. That's expensive for the company.
We haven't even gotten to legal fees for filing the forms and dealing with the SEC. We haven't gotten to accountants and reviewing or auditing financial statements. You know, we haven't got, so the expenses are quite significant on $1 million, you know, probably greater than 10%. So now by bumping this up to 5 million, you've dramatically reduced, I think, the expenses, because the reality is the things that are going to be more or less fixed are going to be your professional service fees, your accounting fees, your attorney fees. The 7.5% is going to be, it is what it is. So it's going to get a little more attractive from that standpoint. But I still think for it to be really attractive, those amounts would probably need to be double or triple of what they are now.
Wow.
That actually raises a good point. You know, all these sort of reforms that are opening up access to these opportunities for investors have a tendencies to reduce the cost of capital raising to the companies, have the tendency to reduce the commissions, let's say, that the company has to pay to their underwriters. And that's you know, and that you're seeing that happen all over the world due to the internet. It's disintermediation. Transaction costs are being reduced to very thin amounts, and that's a good thing, because that's more efficient capital raising if it can be done more cheaply and easily. And creating larger pools of capital that companies have access to will naturally, through the laws of supply and demand, really have that effect, and that's good.
Yeah, absolutely. I actually have a client that we've been trying to bring aboard to YK Consulting. He has a startup for a new crowdfunding, and since the new rule just started for him next week to the 5 million mark, it'll be definitely much cost efficient for them.
That's great. That's great. That's great for everyone, and it brings a healthier and cheaper capital to a healthier economy. That's great. So what do you think these rules changes will make Rule 504? You know, does it make it definitely more attractive, and how?
Yeah, I think so, just based on the experience with one client. You know, to what extent we're going to see an increase, it's hard to say, but certainly, you know, going from 5 million to 10 million is a really nice bump up, because again, you know, seed rounds, institutional investor rounds are likely to be single-digit millions. So now everything is going to be under that limit, and that's a big advantage. The only disadvantage, of course, with the rule is that you can't do a general solicitation, so your entire universe is smaller. But bumping it up to 10 million, I think, is a very positive development, and will, you know, likely lead to more use by more companies. But understanding that, you know, it's perfectly suited to those companies in the earlier stages that are looking for probably single million raises, as opposed to the companies that would otherwise be looking to raise 20 million or 50 million and so forth. So I think in relative terms, it's going to be a success, because that 5 to 10 million jump is very significant.
Right. Okay, so let's move to the next question. So how will the 75 million offering limit for Tier 2 of Regulation A impact capital raises under Regulation A?
Well, I think in similar ways, it's not a doubling like with Rule 504, but I think, you know, companies that were, you know, perhaps looking to raise between 50 and 75 million now have the ability to do it in a very clear-cut fashion under Reg A. And at those amounts, you know, the fees are not going to go up significantly. So the cost of capital in terms of what they're doing is going to be pretty good, because really at that point they're getting into mini IPO sort of raises without all of the costs. I mean, many of the costs, but not all of the costs. So I think it also makes it more attractive to those companies that are already in that space looking at those raises that would otherwise have to think about perhaps using different exemptions or different processes. Now they can just choose one, and that tends to make it easier for everybody involved.
Great. And what do you think the change will impact the demo days?
Well, it'll be interesting to see. You know, I think most startups were completely unconcerned by this. And so I think it was mostly a theoretical problem. Only companies that actually went on to become successful, where the SEC reviewed kind of a series of facts and you know, fact pattern, where there was perhaps streaming video of the demo days, you know, before the IPO. That's where it became an issue. So I don't know that it will solve too many problems, but I think it will. Here's what I think it will do. It will probably make it more likely that more hosts will sign up to do this, meaning the universities, the state and local governments who were probably hesitant.
Who have their own lawyers telling them to be careful at certain points.
Yeah, their counsel was
Not used to the
advising them
laws.
to stay away. So now we've opened up the venues for these demo days. So that aspect for it, I think, is very good. And because we have a safe harbor, it's very clear what the hosts can and cannot do. And I'll just say, lastly, universities and local and state governments are probably the least likely to abuse this because they're going to be bound by their own rules. They're not going to be typically acting as broker dealers and trying to extract commissions, because that would create all kinds of ethics issues for them. So I think it's a really win-win for the hosts and for the, you know, sort of the whole ecosphere of having more venues, more demo days, more companies going through these programs and being brought out to kind of be shown to the public.
Right, and also make it cheaper. Right. So what do you think of, you know, the rules gonna have an impact for like Regulation S or on like foreign companies raising money in the American capital market?
Well, let me just say, just to give some background on that, Regulation S is a rule of the SEC that's been, I don't know, probably since the 1960s. It's actually an attempt by the SEC to limit the ability of issuers here to raise money in foreign jurisdictions. There's always been a real constitutional question or a legal question whether the SEC should have any worry about money raising by a company in, say, Germany or France or in Asia. So there's always been this Regulation S and the concept of, well, you can do things over there if you comply and if you meet with our requirements. And again, that's the US SEC saying, well, if you're going to raise money in Germany, make sure you don't do this and you do that. But there's always been a little bit of uncertainty about it because the SEC, sort of understanding a little bit the tenuous legal ground for many, many decades now, really never addressed it in a lot of detail of how the different rules can work together, this extraterritorial regulation with our very substantial US regulations. So this is really a first attempt by the SEC to say, well, this is how it's supposed to work. And that's clarity for companies, which makes lawyers feel better, which makes everybody feel better. So it's definitely another helpful reform and addressing a sort of slightly unsettled issue in the United States.
Yeah, I like the fact that companies can now, you know, potentially look at neighboring countries to do simultaneous offerings, because, you know, companies typically early on are struggling to find the right investors who are accredited enough. And so opening up additional countries just means they have another opportunity to you know, have a discussion with those investors.
And the practical reality is we have an internet now. So how do you actually say, okay, we're only offering in the United States? Or when they know there could be people in all parts of the world who can see it, what you're trying to do, and maybe are contacted in companies saying, how can I get in? And maybe those are big amounts being invested. A company doesn't want to say no just because they happen to be not in the United States. They want to say yes to everybody, of course. So this is all very helpful for capital raising here.
Interesting. So what do you think the founders rule? What if it's made into real law, and will that influence capital raising?
I think so. I think so. You know, I think my sense is there have been people who have been happy to operate in the shadows, but that's not a majority of people. I think a lot of people who've been trying to be finders or been thinking about being finders have been thoughtful about it and have been talking to attorneys, talking to advisors, trying to understand what are the rules. And the problem is we couldn't give very helpful guidance for a very long time. And I would argue the SEC created this sort of intentional gray area for too long, where it was able to punish people it didn't like or offerings it didn't like. But not really helpful, because what is helpful is not necessarily to have every single sort of breadcrumb laid out, but it's helpful to have guidelines that are clear, and that's what we didn't have. So now we have very clear guidelines. So I think the SEC is doing a real service to the space, so that more people will feel comfortable getting into it, and they will know what they need to do to follow the rules. It won't be a mystery, and they won't have to worry about it and talk to 15 different law firms only to get the same non-answer.
Right. This was another sort of vague part of the law, but there is now, it's sort of clear, well, it is clear that if you don't comply with that safe harbor for finders, you will be considered to be a broker dealer. You will have to register as such, which is that's a big deal for a company to have to do, to essentially become like a bank or an investment bank, or securities broker dealer in this country. There's heavy regulation of those kinds of entities in this country, and finders, on the other hand, are basically unregulated in this country.
Wow. So, this is really
But there's a difference between them too, and it's easy to cross the line, very easy.
Right. Well, I guess we, whoever is in this industry still need, great lawyers' advice and help, because, it's very easy to trip the line, you never know. Okay, so I just want the panelists to know that we have a lot of questions coming in. So I think we have like almost 10 questions. So I'll give you a choice. Do you want to answer the audience question first? Because we don't have a lot of time left, and I do want the audience to feel engaged. What do you think? You're right. Ready? Okay.
Let's do the audience questions.
Great. Okay. So the first question is from an anonymous audience. So what is the average percentage rate of commissions for finders in the tech industry?
That's a loaded question. It's almost impossible to answer. Sort of define I'll put it this way. Everybody's used to getting commissions for capital raising. The standard in this country used to be 6%, just like it was for residential real estate. It's come down from there, but I've seen plenty of companies pay more than that, and I've seen plenty of companies pay less than that. It really depends on the role and really how difficult it is the company to raise, how much effort it really does take. So, there's sort of different markets for different levels of difficulty, really. And it really, there's no standard as far as I know. Kresimir, maybe you disagree. I've seen it all over the map.
No, I think I understand the question. I think it's difficult. I have never seen a data set that looks at this on a really massive sort of big data level. But I can just speak to what I've seen. I've seen anywhere from 2% to 10% historically. So, I agree. I think the trend being lower now as opposed to perhaps 20 years ago. But I think it's kind of anybody's guess. Maybe there's something out there on the internet, but I'm not aware of it.
Yeah, it's a difficult data set. It is. The universe is so large, and a lot of a lot of entities might be reluctant to answer the question unless it's anonymous, and then how do they know it's anonymous, and blah, blah, blah. It's this sort of thing. These things can be trade secrets sometimes, you know, to the entity.
Cool. So it seems like there's a lot of interest in this new proposal for finders. So there's another question on that. Is there any limitation for commission of finders?
Not in this country. No.
Up to?
Not in this country.
Yeah, I'm not aware of any SEC rule that would limit that. I think it's just going to be pure economics negotiations between the parties.
Yes.
And as Claude was saying, perhaps, you know, to view it more realistically, desperation on the part of the company to raise the capital. So yeah, I'm not aware of any sort of upper threshold that would be set up by the law.
And think about it. Sometimes companies don't have the cash to pay the finder or the broker dealer, and they'll have to give them equity to incentivize them further, because that's all they have to give. And what if the equity takes off 10x, 100x? You know, that could be a commission of over 100%. So, but that's okay. That's okay, because there's virtually no regulation of commissions like that in this country. The only time you actually see it is in the residential real estate area. Some states do have restrictions on what a real estate broker can charge. Cool.
Okay, so I think this is a question for Kresimir during the lecture. So he asked, why do you say you need a broker-dealer license for crowdfunding? Is it just because of the advertisement?
Well, yeah, so the way Regulation CF, so crowdfunding exists, is what the SEC said, we'll give you essentially general solicitation, but we'll take in return, you must use a broker-dealer or a funding portal that's registered with us, that's the equivalent of a broker-dealer. So on the one hand, we'll give you something, on the other hand, we take away. So we give you the ability to reach more people through technology, through the relationships that the funding portal or the broker-dealer has, but you're going to be paying them perhaps an engagement fee, you're going to be paying them a commission, you're going to be paying them warrants, etc. So that's the key there. You have to use one of those entities. In other words, the difference is you cannot directly go out and do crowdfunding on your own of this type, where we're talking about selling securities. I'm not talking about there are other types of crowdfunding that I didn't talk about that are of course donation based, that are you know, it's Save the Turtles campaign, things like that. Those are completely different animals.
And that's really how the SEC has some sort of regulatory bite in the crowdfunding space as well, because even though the company might be able to crowdfund in a way that's easy for them, broker-dealers are still heavily regulated. And there's certain things they can and cannot do in any environment. And that's maintained.
Interesting.
And by the way, if part of the broker-dealer requirements are capital requirements, they have to have some money in the bank, to put it simply, to be a registered broker-dealer in this country.
Mm-hmm. Okay, so that's very helpful. So I hope this audience is satisfied. So the next question, do finders operating under Tier 1 need to be registered broker-dealers?
No, so whether Tier 1 or Tier 2, we're not talking about finders being registered broker-dealers. In fact, we're talking about the opposite. So we're saying that if you are a person whose job it is to connect a company with investors, you may do so so long as you fit into either Tier 1 or Tier 2. So long as you, in the case of Tier 1, merely connect the two, you introduce party A to party B, and that's it, you're Tier 1. Or in Tier 2, you will do the introduction, you will perhaps be the conduit for offering materials from the company to the investor, you will perhaps help them schedule a meeting, and that's about it. That's more or less the limit of what you'll be doing. You can really act as investor relations, but you cannot be a broker-dealer. And what I mean by that is you're not holding on to funds, you're not structuring or negotiating the investment, and so forth. You're merely facilitating the investment, but not a key player in it.
Right. And again, the distinction is if you're a broker dealer and if you're engaging in certain kinds of activity vis-a-vis the capital raising, you will be considered a broker dealer. You will be under the law required to register and you will be regulated as such. If you can manage, because of your actual behavior or activity, to fit under the safe harbor of finder, which is really less sort of, is more like an introductory sort of capacity really, less sort of getting into the nitty gritty of negotiating the terms of the deal and actually marketing it to the various constituencies, then you will not be subject to that regulation. But again, it's going to be your behavior that decides whether you will fit that safe harbor or are required to be a broker dealer to engage in that activity under our securities laws.
Mm-hmm.
And you have to be very careful because, and I see a lot of the questions along these lines, it's not something that's really susceptible to generic answers. It's very, all these sort of notions are very fact specific, because this is a huge, you see all sorts of behaviors and activities and contractual arrangements. And guys, let's be honest about it. Many people over many years have tried to structure the contractual relationship and sort of the behavior, if you will, to fit under certain exemptions. But it doesn't always work. That's the answer. The SEC is really going to look at it as the functional realities of what is going on. And a contract could say X, Y, Z, but they're going to say, but you did C, D, E, so forget about it. I don't care about that. It's something that they take very seriously. And there is a self-regulatory organization, by the way, that the SEC overlays, that's called FINRA. And that's their 24-hour-a-day job, is to regulate that industry.
Right. We still need to be very careful, and getting help is very important as well. So let's move to the next question. So it seems like this is from an in-house counsel of a company, because he said we are in the comments period. When does this become policy or law? What date is expected? I guess he's asking about all the rules, right?
No, I think he's asking about the finder proposal. It's hard to tell. We could probably look back at the timeframes where the SEC has proposed a rule and the final rule has come out. So it's hard to say, but my best guess is sometime towards the end of the year, we should have a final rule. Maybe that changes, depends on changes at the top of the SEC and whatever priorities they have. They've announced some priorities that are, kind of different from what we're seeing here. So it's hard to say, but usually, I would think if there's a proposal like in 2020, see a final rule in 2021. There are, of course, exceptions to this. We've had situations where there have been delays of years, but on the whole, I would think that we would have something final in 2021.
Okay, so I'm jumping a few questions because we don't have enough time for all of the questions. So here's an interesting question. So how long do you think the SPAC frenzy in IPO will last?
I think it's already fizzling, if you ask me, but I've been wrong many times before. I think it depends on the performance. It's too early to tell.
Right.
It's too early to tell.
Well, I'll just say I view this as you can just take a pulse of the news stories. If the news stories are all about how exciting these SPACs are, then they're still on the upswing. But now I've started to see the stories about how results of various SPACs are down 20%, right, about how interest is fading. So, these things really can have a very short half-life and can quickly, accelerate and become very, very hot, but can also cool off very quickly.
Look, we're still not sure whether this is partially a consequence of a lot of day traders sitting at home because of COVID and not at their desk doing, having to go to the office. I happen to think there's a connection. And that's why you see what happened with the short squeezes of GameStop and all this. This is just, you got a lot of call it retail people sort of in there. and maybe sort of driving prices in a certain direction that are not necessarily reflective of value. So I think there's a lot of skepticism. You could probably tell I'm one of those skeptics. This is a fad in a way. There was never, by the way, there was never a change in the law that prompted this activity. It just became a social phenomenon. And then one or two guys did it. And a lot of guys have been raising a lot of money over these past few years. Hey, that's a great way to do it, sort of make something out of that and do an acquisition. So the rules were already there. It just became, it's a fad right now. It really is. And it might remain. It might go away. It's hard to tell. Hard to tell.
I agree.
Mm-hmm. Hello. Okay. So I think this is I have like two more interesting questions. So if our panelists don't mind staying for a couple minutes longer, one is one of them is that they ask, are they going to reduce some of these filing requirements due to digitalization and fintech advancement, or will there be an automation options features potentially available?
Well, there already is automation right at the SEC. You can make electronic filings, if that's the question. That's been for 25 years now about, I think. Is that the question?
I think it's for, like, I think this person is trying to explain why there is like a reduced filing requirements. I think he suggests it's because of the digitalization, the technology advancement, something. So like the world is open up. I guess that's what the question is. Right.
Well, let me just say, there's less requirements in the sense of filing because these are exemptions that would tend to get you out of filing requirements, even though it's easier. And in the old days, when I started practicing in the 80s, it was all paper. And yes, we had to file documents like this with the SEC. So they didn't care about that. That's what they sort of liked making people like us do. So.
Cool. Oh, okay. So I think there are a lot more questions coming up, and there are also questions asking when we're having the next webinar, and will there a webinar about SEC's approach to raising funds with cryptos and grants? What other topics for our webinar series? So I'd like to thank all our wonderful panelists, presentators, and Tony, our investment banker, to attend this and take time out of your very, very busy schedule. It's you guys are so busy. It's very rare for me to see all of you guys here, and thank all the audience for attending this hour-long and webinar to listen to our very valuable insights from our wonderful partners and bankers. And thank you all for attending it. And I look forward to having more audience and more webinars, and welcome everyone to follow us, and please pay attention to our news on our website and our LinkedIn page and Facebook page for future events. And we'll keep on bringing you very insightful explanations for the new rules and for the new phenomenon in the economy world also. So welcome everyone, and thank you again for attending. Thank you.
Thank you, Chief.
Thank you very much. Thank you. Thank you, guys.
Thank you, everybody.